Hello, everyone. It looks like we are at our start time, so I'll begin the webinar now. Welcome. My name is Patricia Julianelle. I'm Senior Strategist for Program Advancement and Legal Affairs at Schoolhouse Connection, and welcome to our webinar today on FERPA and students experiencing homelessness. There's my email address. You will see that again at the end of the presentation for the opportunity to email me any follow-up questions you might have. If you're not familiar with Schoolhouse Connection, we are a national nonprofit organization working to overcome homelessness through education. We do state and federal policy advocacy. We have a youth leadership and scholarship program, and we also do practical assistance to school districts and service providers like this webinar that you are a part of today. If you use Facebook, I would just highlight our Facebook group for you. It is a conversation group, so we have a Facebook page like lots of organizations do, but we also have a conversation group where you can ask questions of your peers, you can post examples of documents you're using or anything that you might think might be valuable to your peers, and it's just a pretty good place to go and get advice and information, so I just wanted to highlight that for you. Here's our agenda for today, a couple of housekeeping type items for you. Of course, this webinar is being recorded and it will be posted on our archives webinar page on our website. You do have handouts that are available in the control panel for GoToWebinar. People do frequently have some trouble downloading from the GoToWebinar panel. I think it has something to do with the version of GoTo, I'm not sure. But these documents also are available on our website at the link that is right there on your screen right now. And all of these links, if you download the PowerPoint, they're actually hot links in the PowerPoint, but you can also just go on our website and search for the word FERPA as well. Our website has a search function. So if you go to schoolhouseconnection.org and just type in FERPA, you'll see everything that we've done on this topic, including all of our Q&As. The way this presentation is going to work today is I'm going to do a short presentation, just an overview on FERPA, and then we're going to do scenarios. We really wanted to make this as hands-on as a webinar can be. And so we'll be doing a lot of scenarios and taking some questions from you as well. And just remember that these handouts that are in your handouts pane are also at the link that is on the screen right now. So an overview of FERPA, I'm sure a lot of you know this basic information, that FERPA is the Family Educational Rights and Privacy Act. And what FERPA does is a few things. It ensures that parents and also students who are 18 or over have access to and can protect the privacy of student education records. So I have underlined some words in this sentence because we're going to take a look at them in more detail so that we can really understand how FERPA impacts information that a school might be keeping track of. First thing, what is the definition of parent? Federal education law defines parent in lots of different ways, in lots of different contexts. So for the purposes of FERPA, the way the regulations define parent is to refer to both natural parents, so mother, father, any legal guardian. So again, there has to be some kind of a legal documentation of guardianship there. And then also an individual acting as a parent in the absence of a parent or guardian. So if you look at that last bullet, I'm sure that you have worked with or currently are working with students who have an individual in their lives who is acting as a parent in the absence of a parent or a guardian. That might be a relative, it might be a teacher or a coach, it might be someone that youth is staying with, whether temporarily or longer term. And that individual actually does meet the definition of parent under the law, and so that individual does have all the rights that a parent would have. The only caveat there is that these bullets are in order of supremacy or power, or however you want to look at it. The natural parents have the most rights. After that would come a legal guardian, and after that would come an individual acting as a parent in the absence of a parent or guardian. So if you have differences of opinion among these different people, you always have to go with what the parent says. They're going to be the one who basically trumps the other people, unless you have some kind of a court order that limits that parent's rights. So next to our students, so when we're talking about student education records and we're talking about students, it's an individual who either is now or has in the past been in attendance at the educational institution, and about whom that educational institution maintains records. So the other day I got a question from a person who was working with a family. There were a couple of students who were enrolled in that person's school, but there was also a 3-year-old in the family who was not enrolled in school because she was too young to attend school. And this person at the school was asking if they could do a referral to a Head Start program, if they could provide, this child's name and maybe birth date to this Head Start program. And so we took a look at the law and we said, well, this particular individual who is a 3-year-old child is not and has not been in attendance at the school. She's not a student. And so therefore, FERPA doesn't have anything to do with her. The school does not maintain education records about this 3-year-old child. And so if that person is going to provide a referral to Head Start and provide some information about that 3-year-old, FERPA really has no application at all because that child's not a student. Another thing about students is that once they turn 18, they get all their FERPA rights. So now they get to be in charge and not their parents. There is something in FERPA that says that a parent can continue to have some control over education records if the parent claims that child as a dependent on their income tax returns. But most schools are not privy to the income tax returns of any of their parents whose children go to that school. So someone might say, I claim that child as a dependent, but you don't really know if they do or not, unless for some reason you're seeing their income tax returns, which I suppose you're normally not. So when a student turns 18, you really should be following that student's wishes because FERPA transfers rights to students when they turn 18. It's also important to note that even before that student turns 18, a school may give FERPA rights to unaccompanied youth who are under 18. So once they turn 18, legally the rights transfer to them, and that's who you have to sort of go with, period. But when the youth is younger than 18, the school also does still have the option to provide that youth their FERPA rights. Once again, as I said before, an important thing to remember is that the parents' rights do still have supremacy. So the youth's rights cannot supersede the rights of the parents until that youth turns 18. So if you have an unaccompanied 17-year-old, for example, you can still give them all their FERPA rights, but if their parent becomes involved and starts expressing different ideas and different wishes, then you would have to follow the rights of the parent there. So we're going to dig more into this when we get into all of our scenarios, and I will stop for questions in just a little bit, but I'm just going to get through a few more slides here. Another definition we wanted to look at when we look at FERPA is what are education records? And those are records that are directly related to a student and maintained by a covered institution. So, I think it's pretty clear what records are. You have databases, you have CUME folders, you have items that are there that are maintained in some official way by the school and that are directly related to a particular student. But there are things that aren't education records. For example, a teacher who might write a note and just keep notes about a student. I noticed that Patricia seemed to be sleepy today. She kept putting her head down on her desk. I'm not putting that note anywhere. It's not going into anything that is maintained by the school. I'm not putting it into a database. I'm not filing it in some kind of a filing cabinet down in the office. It's just a note for me as a teacher because I'm just kind of concerned about Patricia, and so I'm just keeping an eye on her. That's not an education record. That's just the teacher's personal note. So just kind of keep in mind that when we're talking about FERPA, we're only talking about education records. Another thing that FERPA applies to differently is what's called directory information, and you may have heard about this. Every school has directory information. It's information that is part of an education record, but it's considered to be pretty basic information that wouldn't really be an invasion of privacy or be harmful if it was disclosed. So that might include a name, an address. It might include grade level, participation in extracurricular activities, You know, if you've ever taken a look at your local paper, you probably see a story about a particular high school athlete that had a great game or a great day. And so they're putting out there to the public that this child plays, you know, basketball or field hockey or swimming or whatever. And that's considered to be directory information. It's important, very important to note that for McKinney-Vento students, any information about that student's living situation is not going to be considered directory information. So even though I just said name and address is directory information, it's really not directory information for a McKinney-Vento student, because address can give away the fact that that child's experiencing homelessness. It might be the address of a motel, it might be the address of a shelter, it might be the address of another family, and particularly in smaller areas, people might know, well, how come that's Patricia's address? There's another family that lives there. I know this other family who lives in that house. And so now you've revealed that there are families doubled up at that address. So any kind of information that has to do with the McKinney-Vento student's living situation cannot be released without consent. That's an added level of privacy for our McKinney-Vento students. So two more things before we jump into our scenarios. I said that FERPA protects access to records and also privacy of records. So usually when we're talking about FERPA, we're talking more about the privacy side than the access side, but it is important to note that it does protect the rights of parents and students to access their records, which means they can look at them, they can inspect them and review them. If they cannot come on site to the school, so typically they would come into a school building, they would show their ID to prove who they are, and they'd say, I'd like to see my child's, you know, CUME file or whatever. Sometimes that is not possible. It might not be possible because the parent doesn't have transportation to get to the office or something like that. It might not be possible because the office is closed because we're in the middle of a pandemic. And so when that is the case, they have the right to have copies of that provided to them. And they can also request changes to a school record if they think that it's untrue or inaccurate or misleading. So you notice that access here does not say anything about my ability to click on a button and go into PowerSchool or whatever database my school system uses and look at my child's attendance, grades, notes that might be in the file. That's not what FERPA protects. FERPA protects inspect, review of education records. And so it's not necessarily, and we even checked with the Department of Ed, there's nothing specifically that says you have to have that kind of online access. You have to be able to inspect the information, but not necessarily just by clicking a button in your living room on your computer. And this comes into play in one of our scenarios later. The last definitional issue that I want to talk about before we do our scenarios is what is privacy? So we know that we're protecting privacy. What does that mean? How do we protect privacy? Well, the first way is that generally, if you're going to reveal information from a student education record, you've got to have consent to do that. Usually that's a parent's consent. Remember, there were 3 different parts of the definition of parent. And it might be the student's consent, depending on the age of the student and whether that student is an unaccompanied youth. So we've got to have written permission. You might have an interagency agreement with another agency that says, we're just going to go ahead and we're going to, give you a list of all our McKinney-Vento students. Your interagency agreement does not change the force of federal law. So you can't do that. You have to follow FERPA, regardless of any MOU or anything else that you have. Those MOUs or interagency agreements must comply with federal law, so they must comply with FERPA. Now, we talk about the need to have consent, and that is true. You've got to have consent, but there are also, if I remember right, I think there are 16 exceptions to the requirement for consent in the federal law. Don't worry, we're not going to go over all 16 exceptions. I pulled out just about 4 or 5 that really come into play a lot with our McKinney-Vento students. So these are some of the exceptions when you don't need permission to release records. The first one, which comes up a lot, is if you're releasing information to other school officials, which could include teachers, who are within that same agency or institution. So in your school district, if you're a charter school, they might be within your particular charter school. If that school official has a legitimate educational interest in the information. That's not particularly defined, so it can be a gray area when you think about who has a legitimate educational interest. But a couple of things to keep in mind. One is you have to use reasonable methods to make sure that school officials only can access the information that they really have a legitimate interest in. So, for example, it may be the case that counselors have a legitimate educational interest in knowing who the unaccompanied youth are in a high school, because those counselors want to help with the FAFSA. They want to help make sure that those students can transition to higher education and complete their financial aid paperwork. So maybe you will provide your counselor, your school counselor, with information about your unaccompanied youth who are in the school. But they don't need to know sort of the whole backstory. Patricia, is an unaccompanied youth because her parents, have a substance abuse issue and her mom is incarcerated and this and that. Maybe the counselor doesn't need to know all that. All the counselor needs to know is Patricia's an unaccompanied youth. Please help her get that verification letter for her FAFSA. And there might be things that she wants to discuss with you that are related to her family situation. There might be things that are very relevant for scholarships, for example, or for what kind of a college would really be most appropriate for her. But that can be a conversation that the counselor and Patricia can have with each other. It doesn't have to be information that's being shared really kind of behind Patricia's back without anybody giving her the courtesy of saying, hey, do you want this person to know this about your mom and your dad and what's going on with you or not? So that's when you're making sure that they're only accessing the information that they really have that interest in. Another thing that I'll just add there is to remember, we're talking about FERPA, but when the student is a McKinney-Vento student, we also have to talk about McKinney-Vento. Those are two federal laws that are equally valid. Neither one is more important than the other, neither one supersedes the other. So remember, the McKinney-Vento Act has lots of things to say about making sure that we remove barriers to retention in school and to enrollment in school. And enrollment, of course, includes full participation for a McKinney-Vento student. So you can think about, and we've had lots of our scholars tell us stories about teachers actually saying things in front of the whole class about, you think that just because you're homeless, I'm going to let you off the hook because you didn't turn in your homework, you're wrong. And now all of a sudden the whole class just heard that comment that the teacher made. Or even a teacher who's really very compassionate and really trying to just be supportive, who might pull a student aside and say, hey, the counselor told me about what's going on with your mom. I'm so sorry to hear that. How can I help? It's a very, very nice thing to try to do. But when that student didn't want the teacher to know, didn't even know that the teacher had been informed, that can really create a situation where the student's embarrassed, horrified, angry, and just disappears and just doesn't want to be engaged in school any longer. So when you're looking at all of these FERPA rules, of course, we have to do FERPA, but we also have to do McKinney-Vento. So we really have to be thinking about both of those laws that might seem like they're competing sometimes. Okay, another exception, you don't need permission to release records when you're sending those records to a school the student's transferring to. So you have a student who has lost their housing, they've left your district, and they don't want to stay in the school of origin. They're going to go ahead and enroll in a new school. You can send those school records over to the new school without having to get a parent sign off on that. If you're releasing records because your state is doing a monitoring, a McKinney-Vento monitoring, or the Department of Ed is doing a McKinney-Vento monitoring, then you can release school records for those kinds of evaluations or audits. The agency that receives that information from you would have their own privacy issues that they would need to deal with. If you are releasing records related to financial aid, so I just gave that example about the counselor who wants to do a letter to the financial aid department of the college about an unaccompanied homeless youth. That letter can be done and provided to the college without any consent because it is in connection for that financial aid. Even if it were a private scholarship, same thing. You can write a recommendation letter for a student that reveals the fact that that student is experiencing homelessness, and you can send that to the scholarship without having that written consent. And then if there's an emergency, a health or safety emergency, you can provide information to the health department, let's say, if they're asking for particular questions related to a health or safety emergency. So I already talked about this, but just remember, we've always got to think about how might this privacy or access issue create a barrier to identification, enrollment, or retention for our McKinney-Vento students. So as we go through the scenarios, we want you to keep those principles in mind. So we're going to start to go through some scenarios. Let me quickly visit some of our questions. So I'll take a few questions now, and then we'll do some scenarios because I think a lot of your questions will be answered as we go through these scenarios. But let me give you a try here. So just a reminder, the webinar is being recorded. It will be posted on our archive webinar page along with all of the handouts as well, so you'll be able to access those. So here's a question about the definition of parent. Remember, I said a parent includes natural parents, legal guardians, and an individual acting as a parent in the absence of a parent or guardian. And someone has asked, does that individual need to have permission from the parent to act as parent? And under FERPA, the answer is no. So you may have a situation where a parent signs some kind of a power of attorney and gives someone else power to access education records, and that's great when that happens because it's nice and neat and tidy and everyone knows who has the power to do what. But under FERPA, if my daughter's best friend gets kicked out or has to leave her house, or I don't even know what's going on, all I know is that my daughter comes home and says, Mom, my friend needs a place to stay for a little while, and I say, okay, fine, and she's staying with me. And remember, it's in the absence of a parent or guardian. So that parent is not in touch with school. Maybe they're around, but they're not, calling the school. They're not trying to be involved with their child's education, and they're really just kind of MIA. I actually can meet the definition of parent under FERPA without any other contact or any other sort of legal document or rights or anything. Is a college student's financial aid file covered under FERPA? So FERPA does cover college students. It covers K-12, but also students. So if a student is enrolled in a college, FERPA would apply to them. Of course, for most students who are in college, they are 18 or older, and so they can consent for the release of their own information, and all of the different kinds of exceptions would also apply to them. So if you want to release information from a financial aid file to help them get additional financial aid, to help them get a scholarship, you can do that without consent, but you can also just go ahead and get the student's consent, and that works too. And the last question I'll take before we do some scenarios, and then I'll take more questions because we have a lot. Do emails count as education records? I would say that depends on how that email is maintained. So, it has to be maintained by the educational institution. So if I'm just sending an email to myself or to someone else with some notes that I took about, oh, Patricia was sleepy today, for example, if that's not being maintained by the educational institution, I would say it's not an educational record. But I would also imagine, I don't know, but you can check with your technology department, but I would imagine that if you're on a school district email address or a school district computer, somebody somewhere is maintaining that, even if you don't know it. So, it very well may be the case that emails are part of an education record because they are somehow being maintained by your school district or by, the school agency or institution that employs you. So I would actually check with your technology department about that. I know, for example, when I worked for the State Department of Education in the state of Washington, we were very specifically informed that all of our emails were public record and could be accessed, and we should know that and behave appropriately. So I would check with your people about that. I would suspect that the same is true for schools and school districts and colleges and universities. Okay, let's do a couple of scenarios, and we will go back for more questions, I promise. But let's dive into some FERPA scenarios. And I want you to know that for all of these scenarios, on your slide, there is a little purple link. That purple link gives you a written answer to the scenario. So we're going to talk about them, but if you want more information or you just didn't quite get what I said, for all of these, you can go to the links that are on the slides and you can get a written answer that probably has some citations for where you can find the law about it and everything. So All of these scenarios are real questions that I really got from schools and school districts around the country. So this one came in, I will tell you that, I think this came from Oregon, if I'm remembering right. So an administrator has changed our data system so that now teachers automatically can see who the McKinney-Vento students are. In the past, I have shared this information on a case-by-case basis when homelessness was impacting a student's attendance. But now my question is, can the school change the database so that teachers can see all of the McKinney-Vento list? And what I'm going to do is, I'm going to launch a poll. It's just going to take a second, and I'm going to give you the opportunity to answer this. It is an anonymous poll. I'm not going to be able to tell who answers what. But let me know what you think. Do you think the school or district can share the McKinney-Vento list with all the teachers? And I'll give you a second to get your votes in, or a couple of seconds. Okay, I see most people have voted, so I'll give you just a couple of last seconds here to get your vote in, and then we will share the results. Okay, closing the poll, sharing the results. This was a little bit of a trick question because I didn't give you all the information. So we had some yeses, some nos, and some I don't know. And in a way, you're all right. So if this is opening up the data system so that, let's say I'm the 6th grade teacher, I can go into the data system and I can see all of the McKinney-Vento students from kindergarten through 6th grade. I'm with the nos. That is way more information than I have a legitimate educational interest in having. Now, if I'm the 6th grade teacher and I can go into the database and I can see all of the 6th grade McKinney-Vento students, but in my school, there are 2 different 6th grade classrooms, then I'm still with the no, because I think I'm still getting educational information that I don't really have an interest in. If I'm the 6th grade teacher and I can go in the database and I can see all of the 6th grade students in my classroom who are McKinney-Vento, then I am in a little bit of a gray area where I think I'm probably with the I don't knows there. I think that absolutely there's a very strong argument that I have a legitimate educational interest in knowing students in my classroom who are experiencing homelessness. It might affect all kinds of things, from their behavior to their attendance to their completion of homework. So I get that. On the other hand, you know, I prefer the case-by-case basis that we have here on the slide for a couple of reasons. One is I'm still thinking about removing barriers. I'm thinking about McKinney-Vento. I'm not sure how all those parents would feel about the teacher knowing information that the parents didn't really want the teacher to know. I'm not sure how the students will feel about it. If it's a small town, I might know some of these kids personally. They might be my neighbors. We might go to the same faith community. So I can see also reasons why it would be better to at least have a conversation with the parents and or the children and say, hey, you know, we'd really like your teachers to know about this. Do you mind? Do you want to tell them? Do you want us to tell them? So I'll say I don't think it's a FERPA violation, but I do think that if we're looking at FERPA and McKinney-Vento side by side and hand in hand, I prefer the case-by-case approach on that one. So thank you for doing the poll. That was a very good one. Let's do a couple more scenarios here, and then we will take some more questions. And we have a couple here on unaccompanied youth because this comes up a lot. So first scenario is a 17-year-old unaccompanied youth. This youth has been kind of bouncing between the youth shelter and his sister's home for several months. Previously, the sister was listed as a guardian within our school information system, but this week, this student's parent contacted the school and asked for the sister's name to be removed and that this sister should not be involved in any way in the student's education. So let's take another poll. First question is, can the parent stop the school from sharing educational records with that sister? What do you think? Yes, no, or I don't know? Okay, most of you have voted, so we'll give you just a couple more seconds. All right, let me close the poll and share the results. Again, these questions are hard. We're not trying to do easy scenarios here. So we have a lot of different answers here. I am with the yeses on this one for a couple of reasons. So let's break it down. In this case, the sister, at least part of the time, the sister has been, it appears, has been an individual acting as a parent in the absence of a parent or guardian. It sounds like the youth was bouncing around, but staying in the sister's home sometimes. Now, we don't know the details. Was he really just sleeping on the couch and living his own life, and the sister really wasn't acting as a parent? Or was she, you know, providing some kind of structure? They were eating meals together. She was helping him out with schoolwork. In some ways, she was acting as a parent. We don't really know that, but let's assume that she was acting as a parent. But now we have an actual natural parent coming in and saying, I do not consent for this individual to access that information. In this case, the parent is, remember, parent has supremacy, parent has the most power. So in this case, the parent can say that sister doesn't get any information. When the parent was absent, the sister could get the information. But now that the parent's here and saying, no, we've got to do what the parent says here. So the second question is, okay, what about the youth though? What if the youth wants to have access to his own records? He wants to see, you know, his information and see what's in his file. Can the school provide the youth with access to his or her own records in this scenario as I have outlined it? Alrighty, I see most of your votes are in. We'll give you a couple more seconds. Okay, I'm closing the poll. And here we have most people saying yes, the school can provide the youth with access to his records, and I agree. This parent has not said anything, at least not yet, about the youth accessing his own records. So if this youth is still an unaccompanied youth under McKinney-Vento, still bouncing between the shelter and the sister's home, the parent is exercising some attempt at some kind of control, but this is still an unaccompanied youth and he can access his own records. And if he wants to go ahead and turn those records over to his sister, that's his problem. He's welcome to do that. Now, if the parent said, I don't want my son to have access to his own records, well, the parent can do that. The parent can restrict the son's access to his own records. So that would complicate things even further, but we're not there yet. And actually, let me just jump. I'm going to jump to this one, and then we'll go back to the previous one, because I think this follows well. We have a student who has been verified as an unaccompanied youth who is 18 years old, and the student has now asked that the parent not have access to the student's educational records. So it's kind of similar to the scenario we just did, except in this case, the student is not 17, the student is 18. Can the student come in and say, no, I don't want my parent to have this? Okay, I can see most of you have voted. We have some pretty wide agreement on this one. Okay, I'm going to close the poll and share the results. So in this case, most of you are saying that the 18-year-old student does have the ability to prevent their parent from accessing education records, and I agree with you. The student could step in and say, I want to have access, I want my sister to have access, I don't want my parent to have access. The only kind of caveat I would add is that one comment that I made earlier about the parent being able to access records if the parent is claiming that student as a dependent. But again, as I said before, how do we know if the parent is really claiming the student as a dependent on their taxes? I'm sure that we could we could ask the parent to prove it, but that's a little bit awkward. And also, again, remember, McKinney-Vento. So we have a McKinney-Vento unaccompanied youth who is saying to you, I don't want my parent accessing my records. If we say, yeah, I hear you, but we're going to do it anyway because we think your parent claims you as a dependent on your tax returns, that really feels to the youth like this school doesn't care about me at all, doesn't care about my wishes, maybe doesn't care about my safety. I don't need to be here. And now you've really raised the barrier to retention for a youth who very well may be on the verge of graduating, and we may be creating a dropout risk. So I think any potential gray area under FERPA here is really overruled by a very not gray area under McKinney-Vento about removing barriers. So let me pause for a second. We have a couple more scenarios to do, but I want to jump back to the questions pane now and get some of your questions before we do a couple more scenarios. Okay, let me take a look here. So we have a question that kind of gets back to one of our scenarios. How do you handle situations where teachers say it would help to know McKinney-Vento status because it makes them more understanding? I totally see that, and I agree with that, and I think that's where we get to that question of, is it a legitimate educational interest? But I think what I would add, though, is I think anyone who works on student homelessness knows that the McKinney-Vento list is not complete. We're definitely missing students, right, who are experiencing homelessness, and the school just doesn't know because not for anybody's fault necessarily, it just hasn't come to light that that student is a McKinney-Vento student. So I think that it actually kind of creates a false sense of security in a teacher if a teacher thinks, okay, I know those are my two McKinney-Vento students, so if that student over there is sleeping or acting out or stealing food, no mercy on that one because, that's against the rules and we have to have that kind of, structure and discipline in the classroom. I think it actually better serves the teacher and better serves the student. Excuse me for 1 second. If we train teachers to know that you have McKinney-Vento students in your class, we know who some of them are, we don't know who all of them are, and so you should, be understanding with everyone. And if you observe anything that you think might be a McKinney-Vento situation, you should let the liaison know because our list is not complete. So I think there's kind of a flip side to that coin that it's important to consider, and I really appreciate that question very much that you asked. Another question, in any instance, can school districts say no to sharing a list of students who are McKinney-Vento to a county education office that supports McKinney-Vento? So I know this happens in a number of states where there's a county education office that might provide trainings or other support to districts and charter schools within that county. I don't think that the school district should share a by name list of McKinney-Vento students with the county unless there's some kind of a data collection protocol that I'm not aware of. As far as I know, LEAs should be submitting data to the state, and it's not name specific as much as it is aggregate. But there would really need to be, I think, consent to share personally identifiable student information between LEAs. So, the county office is a local educational agency. The school district or the charter school is a local educational agency. And you really shouldn't share student-specific information between LEAs unless the student is transferring to go to school there. So it may be that the County Office of Education runs special education schools or other schools, and the student's transferring there. And that was one of our exceptions, if you remember. You can share records when a student is transferring schools. But I'll want to look at this a little bit more, and if you want to send me a specific email about this to make sure I'm digging into it more. This is not a question that I've really considered before, but my instinct is that we're not supposed to share personally identifiable information from LEA to LEA without parent consent in general. Okay, here's a great question. Kind of going back to that legitimate educational interest issue again. What if a parent does not want any information shared with other staff, like teachers, counselors, etc., but the student does, or vice versa? So, in terms of sharing education records, the question would be who controls it. If it's a student under 18, then the parent is going to be in charge of deciding who gets access to those education records. However, a person is in charge of what they say with their own voice, right? So if the parent says, I don't want the teachers to know that my student's homeless, but the student just has a great relationship with the teacher and just goes up to the teacher and says, hey, I'm really going through some stuff. I'd like to talk to you about it, and reveals that to the teacher, that's fine. That's not a FERPA issue. That might be an issue between the parent and the student. It might be an issue between the parent and the teacher, but it's not a legal issue. It's not a FERPA issue. Vice versa, if the student doesn't want the teacher to know, but the parent does, same thing. If the parent wants to share that information with the teacher, the parent can do that. That's not really going to become a FERPA issue. And it would be unfortunate if that creates a situation where the student is afraid to come to school, or, now is embarrassed and doesn't want to come. So of course, we would want the school staff to be as sensitive to that as they possibly can, and to keep it, complete discretion and complete privacy. But it's really not going to be a FERPA issue. Okay, let me take one more question, and then we will jump back into our scenarios for a bit. We have a lot of questions in the questions pane. I think I probably will not get to all of them, but I will do my best. If we have a program that will work with our McKinney-Vento high school students, so this might be a tutoring program, it might be a college transition program, a scholarship program, a local community resource program, but our facilitator needs to reach out to make contact, to follow up, to share services, to let people know, hey, these students could use your help. Do you want to help them, etc.? Can we share minimal contact information? So if this is a program that is outside of your school district, so it's not, if it's a school district program, if it's a Title I program or a tutoring program that you have that is part of your district, then those could be officials of the same school or school district that have a legitimate educational interest in the information. So I'm the tutor, I run the tutoring program at the school, I'm a school district employee. I need to know who needs to be tutored. I might need to know, whether they're McKinney-Vento, so I know that I need to worry about their technology, or I need to say it's okay not to turn your camera on because I get it. So that's fine. But if it's an outside agency that is not a part of the same institution, and you're sharing information that reveals that the student is McKinney-Vento, then that requires consent. So you might not need to share information that the student is McKinney-Vento. Maybe this program provides resources to lots of different kinds of students, and you're just referring a student for resources and not necessarily revealing that the student is experiencing homelessness. Then that's fine. But if this program specifically says, I only want to help your McKinney-Vento students, give me a list, then you cannot do that. You could do a couple things. You could give all your McKinney-Vento students and families the contact information for this program and say, call them, text them, whatever. Or you could say, we have a program that offers X, Y, and Z. Can we give them your information? And then get that approval. I will add that the Department of Education has clarified that consent doesn't have to be kind of old school on a piece of paper signed with a pen. Consent can be electronic, and that even includes an email and it includes a text. So if you get a text from a random number that says, hey, Patricia's information is good to share, tell anybody you want that Patricia's McKinney-Vento, that's not consent because you don't know who that text is from. But if you've been texting with me back and forth for a while about attendance, about school meals, about whatever, and you know my number, and then you say, hey, we have this great program that wants to provide some extra help to our McKinney-Vento students, can I share your information? And I text back yes, that now qualifies as consent. You're fairly certain it's from me because we've been communicating on this number before, and I just gave you what is considered to be a valid written consent, even though it's electronic. So I want to let you know that. Some people have asked here in the chat, is verbal permission okay? Verbal permission is probably not okay. But if you can get a text, or if you can get an email, if you can, get something on some kind of a messenger service, it has to be a platform that's sort of reasonable, and that you've been in touch with this person on the platform. But, particularly during the pandemic and during distance learning, that kind of electronic consent is going to be okay, but probably not just a phone call and I said yes on the phone, because you don't have any way to prove that I actually said yes on the phone. Okay, one last thing before we do another scenario, one last question. All of our homeless students are listed as HCY at the top of their contact page on Infinite Campus, our database. So anyone who has access to Infinite Campus can see that. Is this appropriate? No. The answer is no. Because I'm guessing that everyone who has access to Infinite Campus does not have a legitimate educational interest in knowing every McKinney-Vento student who might be in that database. So you would need to be able to restrict that access to, at the very least, you would need to be able to restrict it to their teachers, maybe, their counselor, maybe their social worker, again, depending on what kind of staff you have at your school. I think that's the very least. I would suggest, like I said before, thinking about McKinney-Vento, I would suggest even more discretion and actually asking parents and students before you share that information. But at the very least, you need to limit it to those individuals who really, truly do have an educational interest in accessing that information. So let me jump to another scenario, and then we'll jump to some more questions. All right, so let's go back to the one that I skipped before, because this gets the electronic records issue again. So we are wondering, we have a 16-year-old unaccompanied youth who would like to remove her parents from the contacts list on the demographic screen on our electronic record system. This means that the parent would no longer get automated contacts. So they're not going to get an automated call, your child did not show up at school today or did not connect to Zoom today. They wouldn't get any of that kind of database stuff. However, it wouldn't prevent the parent from actually requesting access to educational records like a transcript, etc. So let me launch our poll here. What do you think? Can this 16-year-old unaccompanied youth remove the parent from that demographic screen on the electronic database? Okay, most of you have responded. So I will, in just 1 second, close the poll. Okay, this is an interesting one. We have almost an even split among the three answers here. So this, again, was an actual question that we got coming in, and I will tell you the answer first, and then I'll tell you a little bit more context. My answer to this was yes, the unaccompanied youth can remove the parent from the electronic record system. Remember what I said earlier when I talked about what does access mean? Access doesn't mean that I have a legal right. It might be convenient for me, I might like it, but I don't have a legal right to have anybody call me and tell me that my kid didn't show up at school. I don't have a legal right to click on a doc on my computer and, pull up, was my kid, late to class after lunch today? There might be lots of great reasons why we do that. I'm not questioning, whether it's a good practice or not. I'm just saying, do we have a legal right to it? And the answer is no, we don't. So in this case, we've got an unaccompanied youth. Again, remember McKinney-Vento, an unaccompanied youth who is coming to us and saying, I want my parent removed from this. So we can imagine that there's some kind of an issue here, and we want to remove barriers to enrollment and retention for this student. So we want to accommodate the request. There's nothing in FERPA to prevent us from accommodating this request, so we should accommodate it. I will tell you that in this particular situation, this is not actually relevant to the legal question, but just so you know, in this particular situation, this particular parent was taking screenshots of the database with embarrassing information about the student's performance on certain tests and other things, and posting those screenshots on Facebook so that everybody could see all the embarrassing things that were happening to the student in school. And that was why she didn't want her parent to have access to the database. So obviously that really raises the McKinney-Vento flag even higher to say, let's go ahead and remove this parent from the database. Now again, If the parent wants to come in and say, I want to see school records, or, can't come in because the office is closed and says, I want you to provide me access to transcripts, that we have to do. We cannot, prevent the parent from accessing school records, but we don't have to do all the sort of automated calls and the access to the computer screen. So that was a good question that we got in. Let me take another one here because I think this kind of comes up a little bit in the midst of a pandemic, and this is another question that we've gotten. Some of our school nurses are hesitant to share health information for students who are transferring to a new school. So remember I said when you got a transfer student, you don't need parent consent. You can go ahead and send those education records to the new school. That would be inclusive of immunization records and other, health records. I've got an EpiPen, I've got an allergy, whatever. You don't need permission to transfer those records. This person said some school nurses didn't want to do it because they were afraid that that was a violation of HIPAA, which of course is the law that covers the privacy of health records. So, does HIPAA apply to health information that is part of a student's educational record? What do you think? This is a hard one. I had to look this up when I got this question. Definitely did not know it. Okay, most people have answered, so I'll give you another couple seconds before I close the poll. All righty, let's see what you thought. This is one of my favorite kind of questions because it has a pretty clear answer. Not a lot of gray area here. And the answer is actually no. HIPAA does not apply to health information that is part of a student education records. The only privacy law that applies to a student education record, well, that's probably an overstatement, but let me not say that. When we're talking about health records, either HIPAA applies or FERPA applies. So if it's an education record, FERPA applies. If it's, the county health department or your doctor's office or some health provider that is not an educational institution where a student is in attendance, so FERPA doesn't apply, then HIPAA does. So your school nurses, when they are dealing with education records, they only follow FERPA. If your school nurses also, some school nurses are in school, but they actually work for the Department of Health. So they might have some other records that go back to the Department of Health. Those records would be subject to HIPAA, but not the ones that are part of the education record. So that's a little bit of a tricky one, but I think it's probably going to become even more relevant than it ever has been. So I wanted to go ahead and include that. Now let me jump into a couple more questions, and then I think we have only one more scenario left, and I have some resources for you. So let me try to get to some more of your questions. This is a good one here. I conducted a webinar for foster parents recently, and they indicated that they cannot access their children's education records. Is this nationwide? So this is legally, this is not correct. Now, there might be lots of practical reasons why foster parents are trying to get records and they're not being successful getting them. Someone's kind of getting in their way or they're getting stopped, but that should not be the case. I am not an expert in this, and I'd be happy to send you more information if you want to follow up with me with an email. But there was actually a federal law that was passed, I want to say 3 years ago. I believe it was called the Uninterrupted Scholars Act, and it provides additional rights for child welfare case managers and also for foster parents to access school records, just like they were parents, just as if they were quote unquote natural parents. So it may be a case of a lack of awareness of that policy, and there are definitely some organizations. The ABA is one of them that have put out some information on this that people might want to print out and email to their school or take with them to their school or something to try to help make sure they can access those records. Let's see. I'm going to go over a couple of questions that I think I already answered. Here's one that I haven't talked about. Can a feeder elementary school share the names of current 8th grade students eligible for McKinney Mental Services entering the high school district the following year to help with identification? Absolutely, yes. And so there are a couple of reasons for this. One is this is a student who's going to be transferring to that school. So just the way if they were going from an 8th grade in your district to an 8th grade in another district, you could send those records over because they're a transfer student. If they're going from 8th grade in your district, from 9th grade in your district, same thing. You can send those records because that's the school they're transferring to. Another issue would be, if it's within the same school district, then they're still within your same agency, right? Your local education agency. And they certainly have a legitimate educational interest in the information because you have to identify them as McKinney-Vento students, and they might fall through the cracks if the receiving school doesn't know that they were McKinney-Vento. And there also might be school of origin issues too. Remember, school of origin under McKinney-Vento protects the rights of students to follow into that receiving school. If it's a feeder school pattern, even if they're living in a different attendance area, they can follow their feeder school pattern because that's considered to be part of their school of origin. So if that school doesn't know that it's a McKinney-Vento student, they might say, you can't come here, you have to go to that other high school over there. So they need to know about the McKinney-Vento identification so that they can make sure that they get the rights that they are eligible for. So that's a really great question that I've never gotten before. So thank you for asking that one. Okay, let's see. So a lot of people are asking kind of follow-up questions about the idea of teachers getting information. And someone said, if we have database access to a student's McKinney-Vento status for teachers, what about at high school where students might be going from teacher to teacher to teacher? So, one student might have 7 teachers in a day. Do we tell all 7 teachers that student is a McKinney-Vento student? They might also, be when we're in session, when school buildings are open, they might be at recess or they might be at lunch with lots of teachers who are kind of monitoring the lunch, monitoring the recess. Do all those monitoring teachers also need to know? And so this is just really where I go back again to McKinney-Vento. And, does everybody need to know? That's a gray area. I might think that somebody has an educational interest and you might think they don't. There's room for us to disagree on that. And that's okay. Laws like that. But when I think about McKinney-Vento and wanting to establish really good rapport with students, wanting to establish really good rapport with parents, because that's how we do identification. That's how we keep students engaged and keep them going to school. And that's where I feel like if it's a gray area, we should probably err on the side of just asking permission, just saying, hey, we think it might really help if your teachers know this about you. It might help them to, be more understanding, to give you a little bit of a break on your tardiness or your sleepiness. Can we tell them? And let the student or the parent make that call. And the student or the parent might want to tell them themselves too. They might want to say, let me tell them in my way, in my time. This is my information, and I really don't want it shared. So that at least is what all of our scholars and students that we work with really kind of emphasize is, it's our information and it's personal and it's private and we don't need everybody to know. We don't think that everybody has a legitimate educational interest in it. Okay, let's see. I'm just kind of going through the chat box quickly to see what other questions I can find. Someone's asking a question about caregiver affidavits. Excuse me. So are caregiver affidavits required or district policy? I would just say that, for McKinney-Vento students, of course, we need to provide immediate enrollment. And so if they have a caregiver or they don't, or they have an affidavit or they don't, that absolutely cannot be a barrier to immediate enrollment under McKinney-Vento. In terms of FERPA, if we're trying to decide if a person has access to education records, there's no affidavit requirement at all in FERPA. We're just looking to see, is that person an individual who is acting as a parent in the absence of a parent or guardian? So be careful, I guess, with caregiver affidavits. It's fine if someone has them and fills them out and submits them, and they can be really helpful in a lot of ways, but they can't be barriers under FERPA or under McKinney-Vento for sure. Okay, here's someone saying that if a student was 17 at the start of the school year, they give the parent access to school records. If the student was 18 at the beginning of the school year, they do not provide access to parents. So that's an interesting way to do it. I would just say that the law is very clear that when a student turns 18, the student receives FERPA rights. So you couldn't say to a student who turns 18 today, sorry, you were 17 yesterday, so we're not going to give you your rights. They do have rights as soon as they turn 18. So if any kind of a conflict came up about who controls education records under FERPA, it's the student whenever the student turns 18, even if that's during the course of a school year. Okay, I think I've got another scenario. Let me bounce back to the scenarios, and then we will bounce back to any questions that are still remaining in the questions pane. So we have a question here. I give students the FAFSA letter. I'm sure many of you do this, the letter for unaccompanied homeless youth to verify their status so that they can complete the FAFSA on their own without parental information. We know that we can do that without consent, right, because that's related to their FAFSA and their financial aid. So what about scholarship applications, and what about college entrance fees? Sometimes you've got to pay, $50 just to apply to a college. So can I provide verification to those scholarship programs and those college entrance programs without parental consent? And that poll should be launching. Okay, see, I know that we're at 4 o'clock. People are getting tired. I'm trying to go to easier ones, and most people are getting this one right. So I see most people have voted. I'll go a couple more seconds, and then I will close this. So most of you said yes, you can share the information, and I agree, the information is yes. I think the college entrance application one might have put a little bit of a kink in this for some people. The question is, are these related to financial aid? So I could see someone saying, okay, a scholarship, yeah, that's financial aid, but college entrance exam, is that or application, is that really financial aid? It really is, because it is aid that's related to an institution of higher education, and that is based on need. So you could provide information for those fees. Now, a related question is looking at it from the other way. So we've been looking at this from the K-12 perspective. Now let's look at it from the higher education perspective. That college or university, the student wants the college financial aid officer to talk to their liaison and find out, yes, I am an unaccompanied homeless youth. Ask my liaison. Talk to them about it. So can a financial aid officer and a school district liaison speak to each other about a student's homelessness without consent, without anyone's consent? Not the parents, not the youths, not anybody. What do you think about that? Oh, this one's getting tricky. Okay, most of you have voted. I will close the poll in a couple of seconds. Okay, so speaking about a student's homelessness is really not any different than writing a letter verifying a student's homelessness, right? So again, we don't want to speak about details that a person doesn't need to know. So if I'm the liaison and I actually developed a pretty close relationship with the student, and so I know things about the student's family and about the dynamics there, I don't need to share any of that with the financial aid officer. But if I just want to talk about the fact that, yes, I knew Patricia, Patricia's an unaccompanied homeless youth, first year in school, maybe second year or third year in college, yep, I'm still in touch with Patricia. I'm still aware of her situation. She's still an unaccompanied homeless youth. The answer is yes. You can have those conversations without consent, because that is related to financial aid for the student. Again, it's nice if the student knows. Presumably the student is the one saying, yeah, call my liaison, talk to my liaison. But for both ways, for the college perspective and the K-12 perspective, it's fine to share that information in relationship to the student's financial aid. So we already talked about the by name list. Let me leave you with the FERPA takeaways and resources, and then we will get back to the question box. So FERPA takeaway, just remember, I've said this many times, FERPA always must be interpreted in light of the McKinney-Vento Act when you're considering privacy for students experiencing homelessness. So again, two laws, equally important, equally valid. And in fact, you can get sued under McKinney-Vento and you can't get sued under FERPA. So in some ways, you might even think McKinney-Vento is even more important than FERPA is, but I would argue that they are of equal importance. We know, all of these bullets are things that we've already talked about, but just to kind of make sure you take them with you. Remember that trauma-informed strategies are really important for all students. So again, we might give you a list of McKinney-Vento students, we might not, but even if we do, that doesn't mean that that's everybody. All of your students may be experiencing homelessness, they may be going through trauma, particularly now with all of the mental health challenges happening with the pandemic and with racial injustice, and people are stressed out. All of us are. And so those strategies are really important for all of our students. I want to make sure you have a couple of links here. The FERPA regulations here on the bottom left, these FERPA regulations, I would normally never tell anyone to go to their computer and read regulations because they're terribly boring and horrible. But the FERPA regulations are actually not that bad. It's a question and answer format. So it asks a question like, what's a parent? And then it gives you the answer to what a parent is. Who's a student? And it gives you the answer. So they're actually pretty accessible, and you can really learn a lot just by taking a look at those regulations. There was also a really good webinar that the U.S. Department of Ed did back in March about virtual learning and how FERPA applies when school buildings are closed. And I thought that was a really good webinar, so you can take a look at that. And then that link again is where you can get the handouts that were in the handouts pane that I know some of you couldn't access, and get some more information about FERPA, and my email address for additional questions. So let me go back now to the questions pane. We still have about 10 minutes left for some Q&A, so I will try to get through as many of these as I can. Excuse me. Here's a student who's experiencing homelessness, unaccompanied, 18 or older, and has an IEP. How does that change things, the existence of the IEP? Can they restrict their parents or guardians from accessing academic records? So that's a really good and complex question because, again, federal education law just tries to make things complicated. So we have, first of all, we have the McKinney-Vento Act, which gives rights to students. So if you have unaccompanied youth, even if they're 16, 15, 14, they have a lot of rights under the McKinney-Vento Act. They can decide if they want to go to the school of origin to the local school. They need immediate enrollment. Their parents can't disenroll them, et cetera. McKinney-Vento really gives rights to the student. Then you have FERPA that gives rights to the student when they turn 18. Then you have IDEA, the Individuals with Disabilities Education Act, which really doesn't give rights to students ever. IDEA gives rights to parents. So in this case, you're going to have to follow McKinney-Vento because it's an unaccompanied youth. You're going to have to follow FERPA for the youth who's 18 or older and can control now who can access education records. But you also have to follow IDEA, which says that the parent has the right to participate in special education decisions, evaluations, IEP meetings, and they have the right to review those special education records so that they can participate meaningfully in those decisions and those meetings. So now you're kind of in a situation where you're going to need to carefully parcel out what records are going to be relevant for the parent to see so that the parent can participate meaningfully in an IEP meeting. Is the student getting the services that are indicated on the IEP, et cetera? But then there might be information that the parent really doesn't need for that IDEA purpose. And in that case, you're going to need to follow what the student is saying under FERPA and under McKinney-Vento. So I won't go into more detail on that because as you can tell, it's pretty confusing, but it's a balancing act there among those different federal laws. A related question, can an unaccompanied youth designate an adult or caregiver to be in charge of their IEP? That's called a surrogate parent in disability law. A surrogate parent is a person who's not a parent actually, but is able to make special education decisions and participate in special ed meetings. And the answer is no. Again, IDEA does not give rights to students. So a student can't say, I want that person to be my surrogate parent. They don't get to pick who it is. They can, have an advocate. I was an attorney for many youth, and I would go to their IEP meetings, and I would represent them at the IEP meeting, and sometimes I would represent their wishes even against what their parents wanted. And that's okay. But that's different. I didn't go as their parent. I went as an advocate who was, sort of privately advocating for them through a different system. So I won't go into too much more detail because this gets really complicated, but we do have information available on surrogate parents and unaccompanied youth in the special ed context. So if you'd like more information on that, you can reach out to me about that. Now we have a question that kind of goes in a little bit of a different direction. So we have a parent who has made a complaint about the school to an outside agency. So that might be, maybe they've complained to the State Department of Education about a school, maybe they've complained to the mayor's office, maybe they've complained to an attorney for whatever reason. They're complaining about, you violated my McKinney-Vento rights or whatever the complaint might be. Can the outside agency discuss with the school that the parent is homeless? So the outside agency is not covered by FERPA, because remember, FERPA covers education records that are maintained by an education institution. So if I'm, a local attorney, or I'm the mayor's office, and I want to find out what's going on with this complaint that the student has with the school, I can say anything I want because FERPA doesn't have anything to do with me. The question is going to be, what can the school tell me back? And the school cannot tell me any protected education information without a consent from the parent, because it's an outside agency. I can't share information with that outside agency unless I have consent, unless it's some kind of official audit or official monitoring. So again, if it's a monitoring from the Department of Ed, that's different. But if I'm just an advocate and somebody complained to me about something, then the school's going to need consent to release information to me. How must records providing consent be maintained? I would check with your school district on that. I would suspect that your district or your school, if you're a charter school, has some way that they want to keep that kind of consent on file so that if there's ever any kind of a complaint, they can prove that they had consent. So I would ask, whoever it kind of is your privacy officer at your school or your district, how they keep their consent and how they want you to keep it. If nobody knows or nobody has a way, then you can keep it any way that works for you. But just, keeping in mind that if somebody later tries to say, well, I never consented for you to give that information up, you want to be able to access your proof, whether that's on your cell phone or, you take a screenshot or you put it in a file. Whatever works for you to be able to provide that later if needed. Okay, let me try to do one more question before we hang up here. We had a scenario about a 16-year-old who wanted, if you remember, she wanted her parent not to be able to access the database, the school database. And we said the student could do that. The student could prevent the parent from accessing the database. Does that also cover the youth being able to change the address or other information in the information system? So that kind of information about address or other contact information, that's really not a FERPA issue. That would much more be a McKinney-Vento issue. So again, an unaccompanied homeless youth has a lot of rights under McKinney-Vento. And so that would include, I want this address in the database, I want this contact information, I don't want that contact information. That would all be available for the unaccompanied youth to decide, because again, that kind of falls under eliminating barriers to enrollment and retention in school. So it's a little bit of a fine line, what's covered by FERPA and what's covered by McKinney-Vento, but that's really not an access to records or a privacy of records issue. That's really more of a McKinney-Vento issue. Last one, a student employee at a financial aid office for college breaches a homeless student's file because they don't, basically, I'll simplify it, they basically don't like the student. So we've got an employee, and this happens, lots of people, lots of students as work study, they work in the financial aid office as part of their work study, and now I'm working there and I don't like this particular student. And so I start sniffing in their files and I find out that they're homeless. And now I put on Facebook, hey, ha, 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 did everybody know that this person is actually homeless? Yeah, that's a big problem. That's a huge problem under FERPA. There's no reasonable exception for the student to release that information to anybody. That doesn't fall under any of the FERPA exceptions, and there's no consent, obviously, for the student to have released that information. So that particular student employee has violated FERPA and put the university at risk, and I would suspect that there would need to be some kind of disciplinary action about that. So that is definitely not okay. Okay, there are so many questions that I did not get a chance to answer, and I really apologize. Lots and lots of questions came in. Please send me an email. If I didn't get to your question, please email me your question, and I will be more than happy to answer it for you. I apologize that we ran out of time before I could get to everyone, but this was a great crowd. I appreciate you interacting with me and not making me feel like I was all alone out here. So I thank you very much, and I hope that you enjoyed the webinar, and that we'll see you on some Schoolhouse Connection webinars in the future. So thank you so much, and have a very nice day.